Welcome to the debate. Today, we're dissecting a contradiction that sits right at the heart of modern justice. We usually imagine the legal system as a place of definitive rulings, a judge, a gavel, a winner, and a loser. But there is this massive, quiet movement to stop those fights before they even happen, using mediation.
And that sounds peaceful enough, idealistic even, until you hit the snag we're talking about today. Mediation is, well, it's traditionally defined by one core principle: voluntariness. It works because the parties agree to fix their own mess. But the source material we're covering today asks a really provocative, almost heretical question. Is mandatory mediation an oxymoron?
Exactly. I mean, if you force people to the negotiating table, are you saving them from the costs of litigation? Or are you breaking the fundamental promise of the process itself?
It's the classic clash between efficiency, getting cases off the docket, and autonomy, the right to have your day in court.
And I'm taking the position that autonomy, in its current, pure form, is actually failing the very people it's supposed to protect. I'm arguing that without structural nudges, specifically this easy opt-out model proposed in our source material, mediation just remains a theoretical fantasy. The data shows that when you leave the door open but don't sort of push people through it, they just stare at the frame.
And I'm here to defend the right to stare at the frame. Or, maybe more accurately, the right to choose the courtroom. I'll argue that mandating a voluntary process creates a kind of bureaucratic toll booth on the road to justice. If you have to force people to agree, you aren't solving the conflict, you're just suppressing the statistics to make the court system look better.
Well, let's test that theory right away. I'd like to start with my position statement because we have a perfect case study of failure, and that is the European Union.
You're referring to the EU mediation paradox?
I am, and this is really the cornerstone of my argument. Back in 2008, the EU passed the Mediation Directive, and the intention was crystal clear and, frankly, noble. They wanted a balanced relationship between litigation and mediation. They wanted to unclog the courts, lower costs. But they made a critical error. They relied entirely on the parties to opt in. They built the stadium, but they didn't sell any tickets.
And the uptake was low?
Low is an understatement. It was statistically negligible. A major study commissioned by the European Parliament in 2014 looked at the numbers. For civil and commercial disputes, cases that are theoretically perfect for settlement, the mediation usage rate was less than 1%.
1%?
Less than 1%. Even with the directive, even with all the good intentions and glossy brochures, practically nobody used it. This is the paradox. Universal support for the concept of mediation. Everyone agrees it's a good thing, but near zero adoption in practice. So my argument is simple. The purely voluntary approach is a proven failure. The default path of litigation just has too much inertia. Unless you change that default setting with some kind of mandate, nothing changes.
Okay, I have to jump in here because you're framing low usage as a systemic failure. I see that statistic very differently. To me, that 1%, that represents the people who genuinely wanted to be there.
But do 99% of people really want to spend years in court, or do they just not know there's another way?
They want a binding decision. My position is that the integrity of mediation relies on ownership. The traditional definition is that parties control the outcome. So when the state steps in and says, you must try to agree, you're introducing coercion into a space that requires trust. If I'm forced to sit across from the person who breached my contract and I don't want to be there, I'm not negotiating, I'm performing. I'm just checking a box so I can get to the real judge.
That is the box-ticking fear, and it's the standard objection. But the data doesn't really back that up.
Doesn't it? If you force participation, you risk turning mediation into just another hurdle. It becomes a barrier to justice, not a gateway. Defenders of voluntariness, and I count myself as one of them, believe that settlement rates are only meaningful if they're durable. And durable agreements come from willingness, not from mandates. If you force me to the table, I might settle just to make the pain stop, not because the issue is truly resolved.
Then let's look at where the mandates are actually happening. We have a tale of two systems here. On one hand, you have Europe's stagnation with its voluntary model, and on the other hand, you have the success of the United States, which has embraced what I'd call light touch mandates.
Success is a loaded term. Define it for me.
High settlement rates and court efficiency. Look at Florida. In Florida, judges are required to refer most family disputes to mediation. It's not a suggestion, it's just part of the process. And the result? Settlement rates in family cases top 2/3. In general civil matters, where they're also encouraged to refer, settlements exceed 50%.
Okay, but let's pause on Florida. You mentioned family law. It's a distinct beast. In a divorce or a custody battle, the parties usually have an ongoing relationship. They have kids. They have to co-parent. So emotional de-escalation is vital there. Of course, mediation works better than a simplified adversarial trial where a judge just picks a winner. But does that same logic hold when you move to, say, the Eastern District of New York?
It does. And this is where the commercial argument really gains traction.
I mean, if I'm a multinational corporation suing another for patent infringement or breach of some complex supply chain contract, do I really need a nudge to settle, or do I need a legal precedent?
Well, the data says you settle, and you save a lot of money doing it. In the Eastern District of New York, in 2023 alone, they referred over 860 cases to mediation. This includes commercial disputes, Fair Labor Standards Act cases, so these are not just emotional family squabbles. 78% of those cases reached an initial session, and of those, 64% settled.
64% is high, I'll grant you that.
It's massive. And let's look at the New York State level. They launched the presumptive ADR program in 2019. ADR, of course, stands for Alternative Dispute Resolution. And presumptive is the key word. It means the court presumes you should mediate unless you have a very good reason not to.
So it's guilty until proven innocent, but for negotiation availability.
That's a cynical framing. I'd say it's efficient until proven complex. In 2024, they referred 12,000 cases: tort, trusts, estates, commercial litigation. The sheer volume proves that this isn't just for custody battles. The culture is shifting because the structure shifted. When mediation becomes a routine step, parties stop seeing it as a sign of weakness. Oh, if I ask to settle, I look scared, and they start treating it as just a standard phase of litigation.
I admit the volume is impressive, but I do worry about the nature of presumptive ADR. I mean, when you make the alternative the requirement, are you slowly eroding the right to a public trial? There is a democratic function to the courts. They happen in public. Decisions are recorded. Mediation, it happens behind closed doors. It's private. If we start shoveling 12,000 cases a year into private rooms, we lose the public record of how the law is being applied.
I think that's a valid concern for maybe landmark civil rights cases. If you're arguing Brown versus Board of Education, sure, you want a public ruling. But for a contract dispute over a shipment of widgets or a slip and fall, the public interest is in an efficient court system, not a public spectacle for every single case.
But where do you draw that line? You mentioned California in our prep. They've had mandatory mediation for child custody since the 1980s. High satisfaction? Yes, but that is a very, very specific slice of the legal pie. When you apply that same mandatory logic to a David versus Goliath situation, say an individual suing a massive insurer, does the mandate really help the little guy, or does it just force him in a room where the insurer can bleed him dry with delays and lowball offers?
Actually, I'd argue the mandate helps the little guy because it forces the giant to the table early. Without the mandate, the insurer can delay for years, filing motion after motion. With the mandate, they have to sit down and talk in month 2. It levels the playing field by putting a clock on the conversation.
Or they just show up, fold their arms, and say, "We offer 0, and you've just wasted everyone's time and money.
Which brings us to the specific mechanics of the solution proposed in the text. You're describing a hard mandate where you have to participate in good faith, which is, I agree, hard to enforce. But the source material proposes something much more elegant. Giuseppe Di Paolo's easy opt-out mediation model.
I've read the proposal, easy opt-out. It sounds a bit like a marketing slogan.
It's behavioral economics applied to law, really. Here's how it works. When a dispute is filed, an initial mediation session is automatically scheduled. You don't ask for it, it just appears on the docket. And crucially, this session is with a professional mediator, not just a court clerk.
So you're drafted into the room.
You're invited into the room. Because here's the easy opt-out part. It is incredibly low stakes. Any party can walk away at any point. You attend the first meeting, you hear the mediator explain the process, you maybe discuss the possibility of settlement, and if you say, no thanks, you leave. No penalty, no prejudice. The judge never even knows why you left.
But you still had to go. You still had to pay your lawyer to prep for it. You still had to take time off work.
A tiny fraction of the time and cost of a trial. It's like an insurance policy against a 3-year lawsuit.
Perhaps. But I want to challenge the word easy. The text calls it a gentle nudge, but a nudge from a court system can feel like a shove to a layperson. If a judge's order says you have a mediation session on Tuesday and you have to physically go there just to exercise your right to say no, well, that's coercion. You're putting a burden on the rejection of the process.
It is a burden, yes. But is it an undue burden? I'd argue it's a necessary one. Look at the pilot programs in Italy. This is the data that really sells the concept for me. When they introduced this specific opt-out model, mandatory initial meeting, easy exit, annual mediation requests surged from under 10,000 to nearly 200,000.
From 10,000 to 200,000?
Yes. It revitalized the entire system. And here's the thing. Most participants didn't settle immediately, but many did. And many who didn't settle right away came back later because the ice was broken. The argument is that this mechanism creates a space for collaboration where true choice becomes possible. Sometimes you don't know you want to mediate until you actually meet the mediator. You have to taste the soup before you send it back.
I will grant you that the Italy numbers are staggering. But I look at that surge, 200,000 cases, and I have to ask, is the industry actually ready for that? We have to talk about the supply side. Because if you mandate 200,000 meetings, you need thousands of skilled mediators.
And the supply is there.
Is it? Or is it too there? The source material references a survey from the Dialogue Through Conflict Foundation. They surveyed 2,100 professionals, mediators, lawyers, between March and July of 2024. These are the people on the ground.
And what did they say?
Well, 63% reported an oversupply of mediators and a stagnant landscape. 78% said there is still no balanced relationship between mediation and litigation.
Right, because they're underutilized.
Exactly. So we have a glut of mediators with nothing to do. My cynical side looks at the easy opt-out model and sees a jobs program. If you mandate 200,000 first meetings, you are guaranteeing work for that oversupply of professionals. Are we doing this for the litigants, or are we doing it to feed the mediation industry?
I think you're reading the causality backward. The mediators are underutilized because the voluntary system has failed. The survey actually supports my argument for mandates. Those same professionals, 72% of them, identified mandatory first meetings as the most effective tool for boosting mediation use.
Of course they did. If I were a hungry mediator, I would also vote for a law that forces people to hire me. That doesn't mean it's good for the client.
But it's not just self-interest, it's observation of reality. The survey found that good intentions and education campaigns had basically zero impact. Only 3 things drive actual change: judges having the power to pause litigation, economic incentives like fee reductions, and required early-stage sessions. The wall you're worried about isn't the mandate. The wall is the current court backlog. Mediation is the gateway through that wall.
Okay, let's talk about that wall in hard economic terms. Because if we're going to justify this level of state intervention, the financial argument needs to be bulletproof.
And it is. The 2014 study compared the average civil litigation case in the EU to a mediation case. The numbers they're stark. The average litigation cost over 10,000 euros. That's about, $11,000, $12,000, depending on the exchange rate, and took more than 500 days.
500 days. That is nearly a year and a half of uncertainty.
Exactly. For a small business, that's a year and a half of not knowing if you're solvent. Now compare that to mediation. The average cost was about 2,500 euros. The average time, 43 days.
So a quarter of the cost and less than 10% of the time.
We are talking about saving years of a person's life and 75% of their legal budget. The study estimated that if you diverted just 20% of cases to mediation, you could save EU economies nearly 15 billion euros annually. When the efficiency gains are that high, Does the philosophical purity of voluntariness really outweigh the practical benefit to society?
That is the 15 billion euro question. I accept the math. I can't argue that 43 days is worse than 500. But I do want to warn against making efficiency the only goal of a justice system.
Why? Justice delayed is justice denied.
True, but justice forced is justice denied too. The text explicitly states that those savings remain largely hypothetical because the culture hasn't shifted. You can't just calculate the savings on a spreadsheet. If parties feel railroaded, they might reach a cheap settlement just to make the pain stop, not because justice was served. You get a fast result, but is it a fair result?
But the easy opt-out solves that. If they feel railroaded, they walk away in the first hour. They are only forced to listen to their options.
In theory. But let's look at another proposal in the text that scares me a little more than the opt-out, the balanced relationship target number.
Ah, yes. Proposed by the Sustainable Conflict Global Initiative.
They suggest setting a benchmark, essentially a quota, for the percentage of disputes that should reach mediation. They explicitly compare it to carbon emission goals.
It's a smart analogy. We measure pollution, why not measure conflict resolution? We set targets for healthcare outcomes, for education. Why should the legal system be immune to performance metrics?
Because carbon emissions aren't objective bad. We want them to go to zero. Litigation isn't an objective bad. Sometimes a trial is exactly what society needs. We need the Supreme Court to rule on rights. We need public verdicts on corporate negligence. If we set a target number for mediation, do judges start pushing parties into settlements just to hit their metrics? You know, I need to clear 20% of my docket this month, so you two go mediate.
I don't see it as dangerous. I see it as accountability. Right now, the legal system has very few performance metrics regarding resolution speed. A target number just forces the system to ask, are we actually resolving disputes, or are we just churning paperwork? It turns abstract policy into measurable performance. If a court has 0% mediation, that's a failure of case management.
But it risks incentivizing the wrong behavior. It risks privatizing justice to a degree that harms the public record. If the target number becomes the goal, then the quality of justice takes a backseat to the quantity of settlements. It becomes a factory line.
I think that's a slippery slope argument. The proposal isn't to abolish trials. It's to ensure that the 90% of cases that don't need a precedent, the contract breaches, the fender benders, the family disputes, get resolved quickly. The easy opt-out model maximizes client choice by ensuring they actually know what their choices are. Right now, most people don't choose litigation. They just stumble into it because they don't know the alternative exists.
That is a fair point regarding awareness, but I keep coming back to the mechanism of the opt-out. The source material mentions that lawyers drafting dispute resolution clauses in contracts can take inspiration from this model. If two companies agree in advance, hey, if we fight, we will do automatic scheduling, one short session, free exit, then I am 100% on board. That is prior consent.
Contractual mediation.
Yes, but when the state imposes it, when you haven't signed that contract, I worry about the reality of the room. In practice, walking away from a judge's suggestion or a statutory requirement takes guts. It takes a willingness to look uncooperative in front of the court, and lawyers are risk-averse. They might tell their clients, look, we better sit through this and smile or the judge might penalize us later.
I think you're underestimating the robustness of legal counsel. Lawyers know how to say no. But more importantly, the data, New York, Florida, Italy, it all points to one thing. When you build the ramp, people take it. When you leave it as a hidden door in the back, nobody finds it.
And yet, despite all these ramps being built, 78% of professionals still say there is no balanced relationship. We've been trying these nudges in various forms for years. Is it possible that the EU mediation paradox isn't a paradox at all? Maybe people just prefer a definitive ruling. Maybe they actually want the gavel.
Or maybe, as the 2014 study suggests, they just haven't been given the proper structure. The text explicitly says the paradox is a problem of process, not principle. The demand is there, the bridge is just missing.
That's the optimist's view.
It's the empiricist's view. The savings are real. 15 billion euros is not a rounding error. The time saved, 450 days of a person's life, that's not trivial. We cannot ignore that efficiency.
I agree the stakes are high. And I agree that the current system of 500-day wait times is unacceptable. But we must be careful not to throw the baby out with the bathwater.
Let's bring this to a close.
because we've covered the statistics, the models, and the philosophy.
We have, and I'll summarize my view this way. The efficiency is undeniable. I can't argue with the math on the costs or the days saved, but the legal system must be incredibly careful not to erode the voluntary essence of mediation. The easy opt-out certainly minimizes the burden. It's vastly better than a hard mandate. But we have to insist that the right to a day in court remains accessible. It cannot be blocked by procedural hurdles that act as a toll booth for justice.
And I see why you prioritize that. But I conclude that autonomy is actually preserved, not lost, by the easy opt-out model. Europe's paradox proves that simply providing the option isn't enough. The system must provide a structure for resolution. When you treat mediation as a gateway, you aren't blocking the court, you're clearing the path for the cases that truly need to be there.
It's a trade-off, efficiency versus pure liberty.
It is, but the data suggests mediation works best when it is gently required.
Which leaves the listener to decide if that trade-off between strict voluntariness and systemic efficiency is worth it.
Indeed. Thanks for listening to The Debate.